When Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe. That relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did. She moved real quickly. Mr. Baldwin was
Let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6.
having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent looking, I don't think I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a pending...
Lane Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nichols.
Lane Looper walked off the job,
Well,
but he didn't testify.
somebody that was like the head camera guy walked out and looking at Ms. Morrissey because we were in the case. But so if he were to testify that I left the job because of you know, safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, I mean, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like, nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer. That's not actor. Am I being clear on that?
I'm a little confused.
Well, I'm trying. I don't know. I don't remember the scene that you used, but let me just say this. So you're saying, you know, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez. Okay, but let's say the shooting, Sarah Zachary. Okay, when she shot, there were two, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally, I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of, not my job, she was great. I had no reason to doubt.
Yes, but it has to be related to Hannah Gutierrez's
Agreed.
job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns, because that might not be related to Hannah Gutierrez.
I agree with you. It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you absolutely.
In one clarification there, Your Honor, October 8th, 9th, for example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your Honor,
You
but
wanna tell me?
that's an example.
Oh.
If a witness comes in and says, on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe, that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that, then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th, that Mr. Baldwin did not see or know about?
I don't know.
Okay.
Because the other way you could do this is that he was, with respect to, for example, David Hall's, and how he said, well, he periodically checked the gun, and I'm not sure whether there was some kind of I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to Mr. Baldwin.
We do not want a trial within a trial.
Precisely.
That's for sure.
Yes, Your Honor.
But we also want the state to be able to address that, their theory that he should have checked the gun.
Understood, Your Honor.
Okay.
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up, and we'll ask
Yes,
for more
absolutely.
guidance when it comes up
Okay.
more
All right.
precisely.
Okay.
I think I probably stand here, Your Honor, right? We've got the next in limine
Yes, we do.
on
Okay.
inconsistent statements. Is that right?
No. Oh, yes, no. We already did the lay witnesses. This is motion in limine 5, previous contradict the state's. Let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6, and
And there's 7, I believe. Sorry.
No.
Or 5 and 6, I'm sorry. So
okay,
we're back
that's
at
all right.
5.
Let's see. So we're on 5. Okay. Defendant Alec Baldwin's motion in limine to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief. In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker. Or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Miss Hutchins died. It's because of Hannah Gutierrez Reed. And so forth and so on. We put them in the brief, Your Honor. Those statements contradict a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. 2 things. Number 1, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across 2 trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are 2 defendants, the government doesn't know who actually shot the gun and killed the victim, and so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case
Okay,
that the state.
Just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said as a statement of what the prosecutor said in that case. There's a case. I thought this might come up, and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. Court case or federal court, because it doesn't allow that in.
There are 2 different issues here. One is, does it violate due process to do it? And the other is, are we allowed to present the state's contradictory
Okay,
statements?
so I already ruled it didn't violate due process.
Right, and so on the second, and that's what the cases say. That's what Your Honor's referring to. In the Bradshaw case, that the state cites in its brief. It says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation. But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough, to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees with Justice Souter, says the defendant in the second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present, in fact, their own case says we're allowed to present those inconsistencies. On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they said.
Let me find this case, because it went to this. But okay, I'm listening. All right.
And they say 403. But, Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up a small case, for example, that talks about 403 in prejudice, says extraordinary remedy. They don't cite a single case for it, and they're asking for an extraordinary remedy, and all we're asking for is that the statements that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
You want to find the case, please?
Your Honor, with respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. That some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized as long as it doesn't present false evidence or factually or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial, and we'd ask that the court exclude any statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relates to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not. It can be dispositive on other issues, but I want to find that case. I should have just pulled it.
Your Honor, if I may.
Yes.
Two things. As a precaution, if Your Honor would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Garnegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view. But you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that. You could find that, and it was Justice Chavez. All right. Okay, we're on. Steve. Okay, state's motion in limine 7 to prohibit use or testimony of OHSB summary of investigation.
We have attached as an exhibit the summary of investigation that it seems clear that the defense would like to have admitted as an exhibit. So I want to address two issues. One, should the summary of investigation be admitted as an exhibit? And two, should the findings, which I would argue are legal conclusions, be allowed in as testimony? So we've got the summary of investigation is hearsay. The public records exception to hearsay it was never intended to permit something like the summary of investigation to be admitted as an exhibit because it contains legal conclusions. It's actually findings and conclusions. That's what they call it. It contains legal conclusions. It is based on a law enforcement investigation. That's all OSHA does. OSHA enforces the Occupational Health and Safety Act. And in addition to that, the summary of investigation, as you can see, has numerous instances of hearsay within hearsay. And while the defense responded and said Ms. Morrissey hasn't pointed any of those things out to the court, well, they're all highlighted in the attachment. So yes, it's true, I didn't cut and paste everything from the attachment into my motion in limine, understanding that we do have page limits that the court has been concerned with. I can pull up the exhibit and I can certainly go through all of the different quotes where OSHA investigators say, they actually put people's statements in quotes during the investigation. So that's hearsay within hearsay, so those quotes don't come in. The findings and conclusions are legal conclusions, so those don't come in because we can't have the jury hearing that Mr. Montoya and Mr. Genoway came to these conclusions because it's going to cause the jury to think that they now have to come to the same conclusion. The problem with the OSHA report generally is that, one, they didn't do a very complete investigation, and I outlined very specific instances of where their investigation fails. And in addition to that, every time I read the OSHA summary of investigation, I say to myself, what is the relevance of this? What does this have to do with the case against Mr. Baldwin? And I want to put kind of in perspective, admitting not only the report, but testimony about the report is like let's say we're having a DWI trial, and it's a jury trial, and the jury gets to hear about the MVD revocation hearing. That's kind of what this is, only the MVD revocation hearing would actually be arguably more relevant and possibly more admissible than the OSHA, because OSHA is not concerned largely with the conduct of individuals. As you can see, Judge, the OSHA report basically says Hannah Gutierrez didn't do anything wrong. Well, we know Hannah Gutierrez did something wrong. We did an entire trial about it, and a jury convicted her in 2 hours. So it has nothing to do with the charges against Mr. Baldwin. Now, having said that, can the state or the defense call these witnesses that were interviewed by OSHA, put them up on the witness stand? Mr. Halls was interviewed, Mr. Baldwin was interviewed, Ms. Gutierrez was interviewed, numerous witnesses were interviewed. Can we call them and put them up on the witness stand and then refresh or impeach them with the statements that they gave to OSHA? Absolutely, as long as the testimony that they're giving in the witness stand is relevant to the issues in this case. And I'll tell you, on its face, I don't disagree with the findings of OSHA. OSHA found that Rust Productions was responsible under the New Mexico Health and Safety Act for allowing this hazard to be happening on this workplace. I completely agree with them. That doesn't have anything to do with whether or not Mr. Baldwin is guilty of manslaughter. The other thing that I want to point out is the defense wants to do this thing where they don't want you to allow us to bring in anything about Mr. Baldwin being a producer. But what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed, and we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death was the fault of the producers, then we absolutely at that point get to point out that he's one of them. And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being a producer, and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed because they go directly to the fact that he's a producer, and that will open up this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, or I'm sorry, in my motion, he's absolutely a full producer. There are no limitations on his role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
Thank you.
Three quick points, Your Honor. Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, actual finding, and it's a legally authorized report, it comes in under the hearsay exception. We've cited cases on that. Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
He's not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to provide an opinion.
Your Honor, Jorgensen has no factual knowledge of the rest set. What he...
Wait a second. Jorgensen is the guy with the SAY guidelines, right?
That's right. He
So I rule that he gets to testify about the SAY guidelines, but he doesn't get to provide an opinion about the safety.
Correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context and so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Responsible, it said Rest Productions LLC, that's one person's company, is the employer, and the employer, not Alec Baldwin, the employer is the one that is being fined under that report. And so there's a very big difference between saying Rust Productions is responsible for violating these OSHA rules and saying that Alec Baldwin is a producer and he had a contract with Rust Productions and therefore he's responsible. That's not all what the report said. So these are not linked in the way that Ms. Morrissey described. Nothing further, Your Honor.
No, Your Honor.
Okay. Court makes the following ruling. I already ruled that producer liability or whatever does not come in. So this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in by oral and including written, then you have opened the door to producer. And with respect to you saying that the only reason why we may bring it up is because Jorgensen may mention it, Jorgensen's not going to mention it because I already said only safety guidelines. Okay?
Thank you, Your
All
Honor.
right. Okay, so that's granted. I want to keep track of my omnibus order.